And welcome to the League of Women Voters Aurora Area January program. We have partnered with the Santoria Library since we began sponsoring programs. And we are so very grateful to them for the use of the space, the publicity that they do for us, and especially for Allie, who takes the lead. The League of Women Voters was founded in 1920. The same year that women were given the right to vote. So the League of Women Voters was a really big deal. It continues to be a big deal today as we work hard to empower voters and defend democracy. We register voters multiple times a year in a wide variety of venues. We sponsor programs to educate voters on all the issues and government agencies that are in front of them before they cast their ballot. Tonight, we are honored to have Justice Rochford with us as our guest speaker. She was elected to the Illinois State Supreme Court in 2022, having served as an associate judge since 2012. Her accomplishments and publications are numerous, so we gave you a sheet when you came in with all of them on them. We figured you'd rather read them then listen to me tell them, because they are numerous. Please join me in welcoming her this evening.
Winding here. Good evening. Thank you so much for this lovely invitation. I couldn't be more delighted to be here. I am a big fan of the League of Women Voters. Increasing opportunity and advancing the right to vote, and in the process advancing democracy. What could be more important than that? So this is my plan. I'm going to talk a little bit about the Illinois Supreme Court, what we do, how we do it, where we do it, and then I want to engage with you. So please also too, in the process while I am speaking, if you have a question, if you're anything like me, sometimes I forget it if I wait too long. So don't hesitate to raise your hand and interject, because I'd much rather have it be that we were talking about the things that you're truly interested than hearing me drone on endlessly. So our Illinois Supreme Court is made up of 7 justices. And the 7 justices are elected from 5 geographic districts around the state of Illinois. So the first district is all of Cook County, and because the population is so significant in Cook County, there are 3 justices from Cook. There's one justice from each of the other 4 districts outside Cook. I'm elected from the 2nd district, which is 5 counties. It's all of Lake, McHenry, Kane, Kendall, and DeKalb. So right here we are in the 2nd district. I think this is a part of Aurora that is in the 2nd district, yes. It used to be that the 2nd district was made up of 13 counties, included DuPage, and it went all the way from Lake on the east to Joe Davies on the west. It was a much bigger geographic area. But the Constitution provides that the districts are supposed to be equal, not in geography, but in population. And the population has grown significantly in those 5 counties. So the geography got smaller, but it's kind of balanced. Now, when you get down to the district, the 5th district in Southern Illinois, there's like 40 counties. So it's a very different, much more expansive geographically, but pretty even in terms of population. So in Illinois, we elect Supreme Court justices. About half the states in the country elect Supreme Court justices. Only 8 do it where the justices are running associated with a political party, and Illinois is one of those. So I did run as a Democrat, but I can assure you when we are on the court and when we are serving as judges, we are not making decisions based on politics or alliances of gender or ethnicity or religion or anything else. We are really, truly committed to following the law. So each of us has an office in our district. Mine is in Lake County because that's where I am from. And then we get together as a court every other month in Springfield, and we are there for 2 weeks. In fact, I'll go down on Sunday night and the next 2 weeks it's called in term. The court that we have right now is for the first time in history, 5 women and 2 men. So it's it's also historically different than any court previously because there are 3 Black justices, and 2 of the Black justices are women. So we look different than we had before. And one of the common questions I'm asked is, some people say, oh my gosh, how is it with all those women? And other people say, how is it with all those women? But, in truth, I only know it this way, but talking to the men who have been on the court now and had previously, they say it's going pretty well. So I think we're doing great. One of the things that is little known about our Supreme Court, first of all, it's a magnificent building in Springfield. If you have never been, I invite you to come. And if we are in term, I will be happy to greet you myself. And it's open to the public. We have a learning center that is really fabulous. The courthouse was built in 1908. It was modeled architecturally after the Pantheon in Rome and the US Treasury in Washington, DC. It's an impressive and beautiful building. The first floor has some administrative offices. The second floor is the courtroom, which is gorgeous, you have to come see it, and the library. And the third floor, the justices' residence. So we live together in the courthouse. And we each have a suite that is made up of a bedroom, a bathroom, and a little office. But like a dormitory, and I'll be honest, it's a little nicer than the dorms I lived in college, but the lifestyle is very much like a dormitory. We eat every meal together, breakfast, lunch, and dinner. And the beauty of that is that we get to know each other as human beings, and we know about each other's travels and personal lives, children, and struggles and joyful times and sad times, and we really develop this great friendship and trust. This concept dates back to a US Supreme Court Justice, John Marshall, who you've probably heard of. He served in the early 1800s. And he believed that if justices on the court lived together and ate meals together, they'd be more collegial, they'd be more respectful, and in the process, they would do better work. But currently, we are the only state Supreme Court in the country where the justices actually do that. And it really is a wonderful thing. We really like each other. And when we sit at the dinner table, we never talk about the cases. That's always reserved for the conference room. When we sit at the table, we talk about each other as people. And it's amazing when you learn about other people, and we all come from these various places in the state. So we have different experiences and we have different backgrounds. And so, and all of us too have come from different legal backgrounds. Our Chief Justice, Mary Jane Tice, was a public defender for most of her career, for all of her career before she became a judge. Some worked in civil practice. Mary Kay O'Brien, who's from the 3rd District, she and I were elected at the same time. And it's funny because people always want to assume that we're 2 of a kind. We're both about the same age, she's a little younger. We both are Irish, we're both Catholic, we're both women. We seem to have an enormous amount. We both ran as Democrats when we were running for office. But our backgrounds are very different. She was a state rep, she was a legislator for a long time, and then she was on the appellate court. She was never on the trial court. And she comes from a town where the population is a farming town where the population is 200 people. I grew up in the city of Chicago, in a vastly different experience. I had no political background at all when I ran for office, and I had only been on the circuit court. I was in the trial court for the entirety of my time on the bench. So the beauty of us working together and knowing each other is that our difference in experiences it improves, for each other. We're always sharing. Like sometimes we'll say, Mary Kay, how does that work in the legislative process? And she knows, because she was there. And then sometimes I can contribute something about things in the courts because I've most recently been in the trial courtroom. So those kinds of things. So we're always sharing our experiences. Now, we are all equal on the court. Each of our votes counts the same. Nobody's vote counts more than anybody else's. But there has to be a way for us to keep some order in the court too, who, where we sit and who comes in first and those kinds of things. So it's seniority that designates those things, the order in which we enter and exit the courtroom, where we sit in the conference room, even where we sit at the dinner table is actually dictated by our seniority. And when Mary Kay O'Brien and I were both elected on the very same day, it was a question of, well, who would be 6 and who would be 7? Any ideas about how that might be determined? Birthday by age. Okay, that's a good idea. Yeah.
Scissors.
Okay, any other? But by alphabetical, by last name, okay, could be another possibility.
Who's been a judge longer?
Who's been a judge longer? Yes, could be. Who, it's so funny when I'm out talking to high school students, they always are like, well, there would be an algorithm and you would put it all together. But you were closest to being right. The Chief Justice pulls a name out of a hat. So as it ends up, I'm 6 and she's 7, but I feel that we are 6 and 7 because we've been on this journey together. One of the things that I found really interesting is that, there is this preference given to the more senior justices in terms of, the order of things going first and all of that. But when we sit at the conference table and discuss cases and actually ultimately vote on cases, we vote in reverse, we speak and vote in reverse order. So the least senior speaks first and the most senior speaks last. And can you think about why that might be?
To not overweigh the
Yes, because
senior person.
right, because think about it, and there's a human nature in this, and no matter how experienced you are, when you walk in the room, you might be experienced in the law and in other things, but when you walk in this room, and I will tell you, in the beginning, it's a little intimidating being among these Illinois Supreme Court justice colleagues. And if the most senior speaks first and comes all the way down, and by the time you get to 6 or 7, even if you had a different opinion, you might say, sounds good, right? But so having an opportunity to speak first really gives you a chance to say what you really think. And sometimes when you've had an experience that's different and you've more recently been outside the Supreme Court experience, sometimes what you bring to the table can be valuable. And there's a great respect that comes along with, they really listen to us, and they may tell us ultimately that we're wrong, but there is a great respect among us. I can tell you that in the just over 2 years that I have been on the court, there has never once been an angry or disrespectful word among us. Now, certainly we have differences of opinion about interpretation of law, but that's what our job is. But our debate, our discussion is always calm and it is always respectful. So when you come see our court, you are going to notice a couple symbols in the courtroom. One is the seal of the state courts, and it's Lady Justice. She's sitting on the seal on a rock, and that rock represents the foundation of the law. And she's holding in one hand the scales of justice to represent the balance of the work of the courts. And in the other hand, she is holding a sword to express the finality of a court's decision and that it's swift, it should come swiftly. And she's been sitting on that rock since 1818, very patiently. And it was just 2 years ago that women took the majority on the court. And the day that it happened was when my colleague Joy Cunningham was being sworn in, and I could swear she gave a little wink from her perch on that rock. But I love around the outside of the symbol, it's bees. And those bees represent working in harmony and the diligence, the diligence of bees to serving, in that case, the queen, but in our case, the law. So it's very proud. We sit on a panel of 7. You can actually watch our arguments whenever we are in session. They are open to the public, and tapes of them are also always available on our Illinois Supreme Court website. It's a great website for all kinds of interesting information about the courts, so visit it. And you'll see us all sitting in our proper seats. Another thing that I love in our courtroom, on the back wall, so it's not where the litigants are facing, it's not where the people in the courtroom who come as visitors are facing, it's what we are looking at. And it's a Latin phrase, it's audi alterum partem, which translates to hear the other side. And that's really powerful because as human beings, sometimes there is an instinct to jump to a conclusion about one thing or another, and that is not our job. Our job is to hear the entirety of the evidence, all of the facts, consider all of the law, hear both sides fully before we ultimately come to a conclusion. In our courthouse, in our living quarters, in each of our little rooms, which are also designated by seniority, there's a gold plaque outside each room. Mine is called the Farmer Suite, and it's named after the first justice who lived there, Justice Farmer, in 1908. And I'm the 14th in residence in that suite. But there's something also very powerful about living and sleeping and being in this place where all of these great justices have come before us, and knowing their commitment to serving the people of Illinois. It's really quite extraordinary. So again, please chime in if you have a thought or a question. Yes,
When you say where you're seated on the panel,
yes.
is that one long panel or is it kind of an arc or?
It's slightly curved, yes, it is. It has a kind of a gentle curve. Our Chief Justice, sits at the center, and to her immediate right is the second most senior, that's P. Scott Neville. To her left is number 3, David Overstreet from way southern Illinois, and then 4 and 5. I'm in the 6th spot, so I'm at the end on the far right, and then Justice O'Brien is on the end on the far left. And yes.
Just 2 questions. First of all, is your Chief Justice elected or is it done by seniority?
It is done by seniority. So she was elected by the people to be in the position just as we all have been, but she ascends to the position of chief by seniority. Now, after she's the chief, she may choose to continue on the court. She would still be the most senior, but she would no longer be the chief. Having served as the chief, then it's a 3-year term. So then she is currently the chief and the most senior. But if she stayed on, she would be the most senior and no longer the chief. She would have been a past serving chief.
What's the length of your term of office?
Great question. It's 10 years. Yes. And and after 10 years, it's not another open election. So when I ran for this position, it was an open election because they had redrawn the district. Remember, I said it was 13 and changed to 5. And so it created a situation in the 2nd district where there was no justice sitting because the justice from the 3rd district was from DuPage County. That became part of the 3rd district. So it was an open seat. Never happened before. And it was a very hotly contested election. There were 3 Democrats that ran in the primary, and there were 4 Republicans that ran in the primary, and then ultimately the Democrat and Republican ran against each other. But what was your question?
How long your term is?
How long the term is. So after you are elected in an open election that way, at the end of your 10-year term, it's not a contested election. If I were to run again, it would be a retention ballot. So I would run unopposed, and I would have to get 60% of the yes vote to retain my seat. but I wouldn't have an opponent. So when I ran, it was the first time in 22 years that there had been an open election for the Supreme Court. And that's one of the things people don't realize, that our Supreme Court justices are elected, because it happens so infrequently, right? So the 10-year term, and then after 10 years, a retention ballot. It's not typically it's not a contested.
Yeah, I lived in Wisconsin for 50 years, and I was on the league's study of the Wisconsin Supreme Court, and it's quite different. Including they have to run every 10 years, and millions of outside money get poured in for this nonpartisan election.
Well, and that's an interesting thing, because in Wisconsin, they do not run associated with a political party, but it's very much yes, and it becomes I mean, from distant observation, a very political event.
Oh, it is.
Yes.
It's going to be, there's another one coming up, and they're talking millions and millions of dollars from outside the state coming in to influence this election.
We are prohibited from taking money for those judicial elections from outside the state of
That's
Illinois.
bad.
Yes.
How often do you interact with other state Supreme Courts? Do you guys, you obviously spend time together, but do you have reasons to interact with other states?
You know, such an interesting question. So our Chief Justice annually, and maybe even twice a year, goes to a meeting of the Chief Justices from across the state. And when she comes
Just the
back
state, though.
from all the states,
all the states, okay,
all of
sorry.
the states,
Yeah.
the Chief Justice from each of the respective states. Supreme Courts operate very differently in different places. And so when she comes back, she brings all these wonderful stories. We're like so interested and eager to hear all the details of the other Supreme Courts, and it's really wonderful. But I just received an invitation I'm so excited about, and it's going to be in 2 weeks, right after we finish term, to go to Florida. And it's a conference. They invited a Supreme Court justice from all of the states. I don't know how many will actually participate, but it's going to be an opportunity to meet state Supreme Court justices from across the state. For a week, we will be together in conference and have speakers and get to know each other socially. And I'm really excited for the opportunity, because I think there is so much that we can learn from each other. Yes, absolutely. Yes.
What is the current political makeup of the Supreme Court of Illinois?
Okay, it's a good question. It's currently 5 Democrats and 2 Republicans.
Oh, really? I would think that the district south of I-80 would tend more towards the R side.
So the 4th district and the 5th district, which are the southernmost districts, are 2 Republican justices.
Okay, so the rest of the districts are all really in the northern part of the state.
And then 3 from Cook.
Yeah, okay.
I'm from the 2nd, and Mary Kay O'Brien's from the 3rd. But I want to impress upon you that although we run associated with a political party, we shed that when we do our work. And I'm so proud, if you look at our opinions, for the 2 years that I've been on the court, and I've studied those opinions, last year, 80% of our opinions were unanimous, which really speaks to the fact that we work very hard to bring consensus, find consensus in the an interpretation of the law. But of course, there will always be situations where we don't all agree. But if you study the cases, they do not divide based on the political, the way that we have run politically during the course of our elections. They just don't. We split all the time. And I can tell you that we are so sincere in our conversations, in our debate about the law in our conference room, which is all confidential and private, but it is not political. And we don't get to a conclusion and then work our way back on the law. We really follow the law. And that means sometimes there are opinions that can be unpopular. And you may read a headline and think, oh, how could the Supreme Court have done that or ruled that way in a particular case? But I urge you, read beyond the headline. I think that you will find, I know you will find, that the law supports the conclusion, even though it in some cases is not popular. Yes?
How many 2-week terms do you have in a year, and how many cases do you average a year?
Great question. So I'm going to start here. Well, first of all, we meet 5 times a year. We start in September, and it's every other month: September, November, January, March, and May, and we don't meet in July. So the circuit court across Illinois hears about 1.6 million cases a year. Across the state, trial court level, 1.6 million cases. If you don't like your results at the trial court level, you have an absolute right to take an appeal to the appellate court. About 4,000 cases a year get appealed to the appellate court. There's an appellate court in each of the 5 districts that we previously talked about, Cook County, and then the 4 other districts outside Cook. But to get to the Illinois Supreme Court, you have to ask the court's permission. So you file what's called a petition for leave to appeal. And you say to the Supreme Court, please give me an opportunity for this case to be heard again. And there are 3 different circumstances that we hear cases. One is if there's been a finding of the law is unconstitutional at the trial court level, it comes straight up to the Supreme Court. That's one. The second is where it's called a direct appeal to the Supreme Court. But the other 2 circumstances are when the court finds that there's a conflict among courts in Illinois. So maybe there's an issue that's kind of a similar or common issue, and the 2nd district has ruled one way, and the 4th district has ruled a different way. So the Supreme Court is likely to get involved in that case because we want to establish clarity, because courts are always looking at what other courts do. That's precedent, and that's how you determine what law to follow. But if the law is in conflict, then the Supreme Court can step in, consider both ways that those matters have been resolved, and then resolve that conflict. Yes?
Do you mean that the same case would have been heard in the 2nd and the 4th, or that there were similar cases and one ruled one way? How do you know that there's that conflict is what I'm asking?
Okay, so it's not the same case.
I didn't think
Yes.
so. Okay.
So it's that there's a similar issue.
Okay.
And so when you're making your appeal to the Supreme Court, you're saying, look, this issue has been heard several times in the state of Illinois, and the courts have ruled differently on this very same issue. And so then the Supreme Court says, okay, that's the kind of thing that we would want to hear because we want to resolve that issue. The other cases that the Supreme Court will hear is if they're of general importance. So it's something that is going.
Excuse me, I'm sorry.
Oh, that's okay. That's right. Something that's going to impact or affect a broad number of people. So we don't take a case that's just interesting, or even just because we think maybe the appellate court didn't get it right, but it's only going to affect the parties in that particular case. It must have a broader impact for us to hear it at the Illinois Supreme Court. So back to numbers. You asked me how many cases do we hear at the Illinois Supreme Court? So there isn't a number, there isn't a magic number, there isn't a maximum or a minimum, but it's typically about 70 or 80 cases a year. And so those are spread among these 5 terms that we hear them in September and November and January and March and May.
So what are some of the cases that are coming before you this year?
So, we are hearing cases. I don't talk about specific cases. First of all, anything that's pending, I would be prohibited by canons of ethics to speak about.
What are some recent ones?
But we're hearing all kinds of interesting cases, and that's one of the things that's very different than being like on the circuit court where, when I was in the circuit court, I was assigned to the family division, or I was assigned to the probate division, and you become really well familiar with that area of the law. You are invested in it, and you've studied it, and you feel a certain sense of familiarity and confidence. At the Supreme Court, we are hearing all kinds of cases. About half the cases are criminal cases, about half the cases, and not exactly, but usually we hear criminal cases in the first week and civil cases in the second week. The criminal cases take priority over civil cases, so we'll hear a maximum of 24 cases in a term, which is a lot of cases. And if the criminal cases take precedence because we're talking about somebody whose liberty is at risk as opposed to just finances. But you know, everything that you can imagine that is heard at a trial court level, we can hear at the Supreme Court. Fascinating cases, some of them are now dry and not so fascinating, but they're all extremely important. Yes?
So what is your process? So you get this case and you're going to meet in term, and how do you go about doing this? What is it that you do, and do you have a time limit that you have to adhere to?
Great question.
Or flies on the wall, what would you?
Yeah, yes. So first of all, we each have our own office, and in our independent office, mine again is in Lake County, I have a staff of 4 law clerks, 4 full-time law clerks, an administrative assistant, and a marshal. My marshal's here with me tonight, and he's my security person because unfortunately, courts judges can be unpopular, and so we have a security person who is assigned to us. But our law, and every office handles their caseload a little bit differently, but generally this is how it works. The court grants a petition for leave to appeal. So you file a petition for leave to appeal, the court considers about 2,000 petitions a year and winnows that down to about 70 or 80 cases based on the criteria that I just discussed. And that happens by sending, so independently, each justice gets the petition for leave to appeal and studies it. It comes to us first having gone through a research department, and they make some basic findings, bring some things to our attention. Then in my office, one of the law clerks is assigned the case. He or she digs in deep on it, then I study it, and then we each anonymously vote, all of the Supreme Court justices anonymously vote yes or no to accept the petition for leave to appeal. No one knows how anyone else has voted, so we're not influenced by anybody else's vote. When we meet, it'll be Monday that we all get together, and it's revealed what all the votes are. And so we see which cases the petition for leave to appeal has been granted on. It needs 4 votes. Everything in our court requires 4 votes. Now you're thinking, well, that makes sense, that's a majority of 7, but it's not a majority. It's 4 votes. So there will be cases where a justice is not participating, we call it NP. He or she has recused herself for one reason or another. Maybe 2 justices have. So there might only be 5 justices hearing a particular case. You still need 4 votes to accomplish anything. So the petition for leave to appeal, but we sit at the round table and we go through them. And I would have another opportunity. For example, if I thought, oh, they're missing the mark on this case, this is something we need to hear, I could ask my colleagues to let me speak to it and say, let me explain to you why it didn't get the 4 votes, but I think this is really important. And they listen, and sometimes the votes change. Or the opposite. I might say, I know we've got the 4 votes for this PLA, but I'm concerned that this isn't the right case for one reason or another. I'm afraid we won't get to the issue we're trying to get to because there are other preliminary things that are going to prohibit us from getting to the meaty issue we care about here. And then again, we take another vote, and then ultimately the PLA is granted, okay? So the case is coming to the Supreme Court. There is an opportunity, the parties file their briefs. The petitioning party files their brief, the responding party files their brief, the petitioning party has another opportunity to file a reply brief. When it's fully briefed, it gets assigned to the court, the Supreme Court, for oral argument. And we hear oral argument on every case. So, and then the cases are assigned, now unlike the US Supreme Court, where cases are assigned to the justices at the discretion of the chief, and usually based on because they have a strong feeling about it. I don't exactly know how they do it with the US Supreme Court, but it's very different than the way we do it. We randomly, it just goes around in a circle. So I might have voted against accepting a particular case, and it might have been granted, and it might be assigned to me, and that's fine. So before oral argument, we dig in again. We really study the cases. So if you ever watch the oral arguments, you'll see the justices are prepared. We do not go in cold, and there can be a great and lively exchange of questions with the attorneys. And then we go back into the conference room, and it's just the 7 of us. No one else is there with us. And we talk about the cases. And then we take an impression vote, which is really that. It's an impression. I studied the case, I heard the oral arguments. If I were gonna vote today, this is the way I think I would go. And then the person who is assigned as the author has that information, kind of knows where your colleagues, where their impression is on the case. And then you go back to write, and you really dig deep. And sometimes you'll even be surprised. There are times where I've had an impression on a case where I thought it would go one way, but when I really dug into the law, I realized that it really should go a different direction. If I'm the authoring justice, then I prepare a draft for circulation. And in terms of a time limit, it's not a time limit, but I hold myself to a time limit. When we hear orals in January, I want to be circulating my draft before the March term so that, we just keep things moving. And then at the March term, when we all get together again, we have more discussion about what I've written, and we vote on the case. And if I get 4 votes for my draft opinion, then it will proceed and be the published opinion. But one of my colleagues who disagrees with me might say, well, I agree with the ultimate conclusion, but I'm just not on board with how you got there. So he or she might write a concurring opinion. So it's an opinion that's attached to my opinion, and it says just that. I agree with the conclusion, but can't go along with the analysis, for example. Or a colleague might say, I completely disagree. I'm going to dissent. I'm going to depart from the majority in the case, and I'm going to explain why. And those dissents can be very, Ruth Bader Ginsburg was famous for her dissents that had great influence and impact, even though they did not prevail when the case was originally decided. So speaking up when you disagree can be very important. And I will say our court, again, doesn't, you don't take it personally. It's not personal. It's a genuine difference of opinion about interpretation of the law. So, and then after the opinion has been accepted, and then the concurrences or the dissents are written, it ultimately goes to publication. The week that it's going to be published, there's a public announcement made. Smith versus Brown will be released on Thursday morning at 9 a.m. and then the release. And people who are really into these things are waiting for those cases to be released. Obviously, if it's a case that you're involved in, or just the people who do appellate work, they're waiting anxiously for those release dates. Yes.
That's a follow-up question. You said that if a justice recuses themselves, obviously then you would have perhaps 5 justices voting on a case.
Yes.
Do they still need 4 for that to be approved?
Yes, absolutely.
So it's not a question of, okay, so.
Right. And that's really, that's a really important thing. So let's say there were 6 justices that were participating in a case, and let's say the justices were split 3 and 3. If there aren't 4 votes, the Supreme Court cannot rule. It's called a Perlman order. It's a 49-year-old case that, because the Constitution says there has to be 4 votes. And there's case law that interpret that to mean that then the Supreme Court can't rule if there aren't 4 votes. So the lower court decision stands. What else? I love you're fabulous. Great questions.
How often does that happen? That you cannot rule?
So it has happened a couple times in the 2 years that I've been on the court, which has been more than it had for a long time. But some of that might be attributed to the fact that there are so many new justices on the court, and sometimes there have been more not participating situations because when justices are newer on the court, they sometimes have touched a case. Like if you're on the appellate court, you might have ruled on or been somehow attached to a case because on the appellate court, so you couldn't participate. And there are four of us that are just 2 years, a little over 2 years on the court. So there are more cases where there are not participating judges, if that makes sense. And so it has happened, I think maybe 4 times in the last 2 years. But it doesn't happen all the time, but that's a lot actually in the grand scheme of things. Yes. What else? I love these questions.
Ethics? Is there?
Ethics. Okay, the state of Illinois, I'm very proud to say, has a very strong code of ethics that every judge in the state is required to comply with. And you know, it's wonderful because we know what the rules are and then you follow them. And if you don't follow them, then there are consequences. And you know, in the event that there is a concern that a judge has failed to comply with the code of ethics, and the code of ethics can, I mean, it addresses all kinds of things, how we participate in cases, how we rule on cases, how if we're running, you know, ethical determinations about what we can and can't do on the campaign trail, who we can speak to. It's okay for me to be here speaking to you, but there are some groups I shouldn't be speaking to, like politically associated groups, those kinds of things. I think we're very proud of our code of ethics. If somebody feels that a judge has violated the code, then you can file a complaint with the Judicial Inquiry Board. And the Judicial Inquiry Board does an investigation and ultimately could bring a charge against the judge or could dismiss the case, making a finding that it was not supported by facts, or you know, that there was nothing really there. Ultimately, if a judge is charged formally, then that case is heard by the Illinois Courts Commission, which is made up of a panel of 7. It's 1 Supreme Court justice, it's 2 appellate court justices, 2 circuit court judges, and 2 non-judges. They could be an attorney or it could be just a lay person. Yes, appointed by the governor. Those are appointed by the governor. And then this panel makes a determination, here's a trial, and makes a determination of whether or not the judge has breached the code of ethics. And if there is a determination that the judge has in fact breached the code of ethics, there are 3 basic sanctions. One is removal from the bench, the most extreme. One is a suspension from the bench for a specific period of time. Or one is a sanction of an admonishment. So telling the judge, shouldn't have done it, and you know, don't do it again. Yes?
Is there, the panel, does it change with each case, or is it a set panel that here's all cases?
It's set for, there are terms for each of those positions, and then, but it changes over the course of time depending on how long the person has been appointed for. It's like, I think it's like a 3-year term. Yes. Yes.
How does something get to the US Supreme Court then? Like what, because that's the only thing above you, right? There's state Supreme Courts and then the US Supreme Court, or is there something?
So we are the highest court in the state of Illinois. So matters that are a question of Illinois law are heard by us, and we are the final determination.
Okay.
Sometimes there are issues that then there's the federal court system, and those cases go potentially to the US Supreme Court. But there could be a case where if we interpreted a law, for example, and then someone was saying that Illinois had interpreted it in a way that was a violation of the US Constitution, potentially they could petition the US Supreme Court to take one of our cases too. It does not happen very frequently. It's not like every decision we make is subject to appeal to the US Supreme Court. It's only if it's something that actually affects the US Constitution, yes. But sometimes there are interesting things like federal courts will be addressing a specific issue, and there might be an Illinois law that's part of their interpretation, and sometimes they'll certify a question and send it over to the Supreme Court and say, help us to understand what this means, this law means, and then it's our job to consider the interpretation of that Illinois law and then send them an answer back. So, yes.
As things get potentially sent back to the states for decisions and laws and so forth, do you see that there could be more and more of that going on where the state's interpretation or the state's laws were challenged as federally unconstitutional?
We'll see. Yeah, we'll see. Yes.
As far as like the cases that go to the Supreme Court,
Yes.
is there a limitation on like the districts? Can any district send any amount or?
Yes. Yeah, I mean, so the cases are, heard in the appellate courts all across the state. And when we are deciding whether or not to grant a petition for leave to appeal to take that case, we are not considering that the second district had a certain number or fewer. That's just not a part of our consideration in determining whether or not that PLA should be granted. It very strictly relies on whether or not there's a conflict in the state or whether it's a matter of general importance. And if in one particular year the majority of them came from whatever district, that would be fine. Yeah. What else? So many great questions. I don't even know, 7:30. Okay, yes.
I was just curious about requirements as a judge, if you're gonna run for the office. Are there some requirements or?
Yes, well, that's a great question. So in Illinois, to run for the Illinois Supreme Court, the only thing you need to have is a law license. Now, I will say that typically you will submit yourself to bar associations for evaluation. And typically a bar association, when considering your qualifications, they will consider what your practice has been, what your experience on the bench has been, your experience in the courtroom, all of those kinds of things, in making a determination to recommend you as highly qualified, or not qualified. And the Illinois State Bar Association does evaluations, local bar associations do evaluations, and people rely on those because it usually has two components. One is a group of evaluating attorneys that are studying the various candidates, and then also attorneys working in those various districts, either across the state or locally, fill out questionnaires about these people to consider not just their legal experience, but also their temperament, their ethics, those kinds of things. So I will say that traditionally, bar associations will not find an attorney who's been practicing for a year qualified for a judicial position, but that doesn't mean he or she can't run, and it doesn't mean that he or she can't win. So,
Why is it that you chose Very important. Wonderful.
So, never dreamed of it. It wasn't something, I will say my career to the bench was very incremental. And I think it was exactly where I was supposed to be as a judge in Lake. I practiced for 25 years, had a private practice. I also did government work. I worked for local villages. I was a commissioner of the Court of Claims. I had done a great variety of work. And one of the things I knew about myself, I have a girlfriend who's really brilliant attorney, and I said to her, oh, Jennifer, you should be a judge. And she's like, that would be a terrible judge. I'm an advocate. I love to go in and fight for the side that I think should prevail. My personality is really a little more balanced. I want to hear both sides and I want to find resolution in the middle. So it kind of suits me. And I loved the work. And when I was appointed as an associate judge in Lake County, it was just fabulous. I loved the work. When this opportunity presented itself, I knew it was a once in a lifetime opportunity. As I say, there had been an opening on the Illinois Supreme Court in the 2nd District for 22 years. And I knew in my lifetime it was not going to come again. It was an open seat. And some friends and supporters contacted me and said, this is your time and you need to go. And it was, because I was not a political person. That was not the kind of, I never expected to put myself in a situation like that. Also too, you'll hear people very, very critical of electing judges. But I will say that there's no perfect system, because if people are appointing judges, there can be bias and political influence in those appointments also. The beauty of running for me was being out and about every morning, noon, and night across these 5 counties, talking to people about the work of the courts and hearing from people about their concerns about the work of the courts. And so it was a 2-year process, and I was working full-time in my regular courtroom and then campaigning every weekend, night and day. We saw some of each other over the course of things. And even if I hadn't won the election, I would never have regretted the opportunity to be out and about talking to people about the work of the courts. I think it is essential. There are certainly things that judges cannot be out talking about, but there is so much that we can be out talking about, and I think it builds confidence. I'm so proud of the work we do in the courthouse, and I think it builds confidence if you know transparently what is going on, and you feel a freedom to ask questions and inquire as you have this evening. I think it builds confidence in the work that we are doing. So I'm a believer. It was a once in a lifetime opportunity. I'm passionate and committed to the work of the courts. The other interesting thing I will say about the Supreme Court is that when we think about it, we think about hearing these big cases. That is only a piece of what the court does. The Supreme Court is the administrator of the entirety of the Illinois court system. So we have additionally 30 committees and commissions across the state that do a variety of important work. I serve on the security committee. I serve on the Commission on Professionalism. I serve on the Professional Responsibility Committee, the Committee on Domestic Violence. We have committees on elder care. We have committees on juvenile justice. So all of these other important things that are affecting courts, access to justice, making sure that the courts are available and accessible to people all across the state, being out and about across the state too. I realized, I sat in Lake County and I kind of figured, well, it must be pretty much the same all across the state. It's not until you are out and you see how differently courts operate, how distant people are from courthouses, how unable they are to get there, that they don't have Wi-Fi access for genuine access to the courts. I mean, all kinds of things like that. I'm very committed in matters of access to justice. So it's my life's work. I'm passionate about it. I am proud of the work that we do. I'll be the president of the Illinois Judges Association starting in June. And I'm gonna be traveling around the state and asking every judge once a year, go to your Rotary group, go to your church group, go somewhere in your community and talk to people, answer questions about the work of the courts. Because we shouldn't be in an ivory tower, and you shouldn't be wondering and worried about how we do and what we do. We are here to serve the people of the state of Illinois and dispense justice fairly and openly. And I'm very committed to that concept. So I guess that's a really long answer. It's not a simple one thing decision. I talked to my family about it, my husband and my children, and when you put yourself out there publicly, you open yourself to attack. That's not easy. But I would never have regretted the journey, even if it hadn't turned out as it did. I'm sure glad it did, though. Yes?
What are the state ethics regarding gifts and money?
So we file an annual disclosure of anything that you receive from anybody, but you really shouldn't be receiving gifts from anybody. But if you do, if someone, pays for a dinner or, whatever it is, then you disclose it, so it is public. I try to pay my own way, and it just makes things certainly easier and keeps my conscience clear. I will say, when you're running for office, you have to raise money because it's expensive to run a campaign, but judges cannot raise money. So if I was on the campaign trail and I was out speaking to you, I would have to leave the event, and somebody on my treasurer or somebody on my financial side of my campaign could make an appeal for a contribution, but it's a completely separate piece of the campaign. You don't know who donated to you. You can't solicit donations. You can't touch that money. You really can't have any association with it at all. And it makes it easier because you're doing your work and the money is separate. Yes?
So, that money is separate, but now you can go to the Illinois State Board of Elections website and I could look up Sandy Sue for judge. And if Sandy Sue has received, I think it's $5,000, then she has to start filing. And there's a list of people that donated. Is that not money that judges are raised when they're running for office? Is that not recorded?
It is publicly disclosed.
It is public, okay.
But the judge, him or herself, cannot solicit those funds, cannot be involved in the investment of those funds, touch those funds. There's a campaign committee, finance committee that is separate from the judge. It is all publicly disclosed.
Okay, so
yes.
You don't even write a thing, you just.
No, my campaign might,
Okay.
but I don't have anything to do with the money. The candidate, a judicial candidate, the ethics for judges running for office are different than any other office. I will tell you too that when you are campaigning as a judge, people want you to answer questions like how you feel about certain important issues, gun control or abortion or whatever. And a judge has to remain completely independent. And people say, well, how can I trust you if I don't know what your opinions are on those things? But a judge can't really have those opinions because you have to, when the case comes, you have to look at the law and the facts and the circumstances, hear the other side, and then ultimately rule. Unlike the other branches of government, the legislative branch, where they are trying to actually change the law, advocate for specific positions. That is not the job that judges are here to do. So it's different. Any last question? I think we're over our time. What a privilege it has been to be here with you. Thank you for all the wonderful questions coming out on this cold night, your enthusiasm. I hope you'll be proud of the work that Illinois courts are doing. I know I certainly am, and it's my privilege to put on that black robe and serve the people of Illinois. So thank you.
You also had to come out of this cold night and came from Chicago, I understand. So we thank you very, very much. You gave us a lot of information. And Allie is reminding me that there's some evaluation cards back there. It helps the library to hear evaluation for the program, so if you have time, take one and fill it out tonight before you leave. Again, thank you very, very much.